Good to go.
All right. Good afternoon. This is a meeting of the Massachusetts Gaming Commission, meeting number 539. I'm Jordan Maynard, and I'm serving as chair of the commission. It's approximately 12:03 on November 7th. We are holding this meeting virtually, so I will do a roll call. Good afternoon, Commissioner O'Brien.
Good afternoon, I am here.
Good afternoon, Commissioner Hill.
Good afternoon. I'm here.
Good afternoon, Commissioner Skinner.
Good afternoon.
And good afternoon, Commissioner Broder.
Good afternoon. I am here as well.
Well, thank you. And so I'd like to, before we begin, welcome Paul Broder as a commissioner to his first public meeting. Second meeting of the day. We did have a hearing earlier today, which is why we're starting a little later. We'll try not to double up on those, Commissioner Broder, going forward.
No worries.
Paul comes to the commission after a successful career serving his community of Melrose, first as a state representative and then as mayor. Commissioner Broder's background will be an asset to this commission as we work to ensure the positive impact of legal gaming on the legal gaming industry in Massachusetts. I also want to share my appreciation to him for being willing to serve, and my appreciation to Governor Healy and Lieutenant Governor Driscoll for their very thoughtful addition to our team. With that said, I'll ask Commissioner Broder if he wants to say anything, and then all the other commissioners if they would like to say something. Commissioner Broder.
Thank you very much, Mr. Chairman. It is a pleasure to be in such esteemed company. Your reputation as a commission certainly precedes you, and I am happy to join in as part of the effort. I do want to thank, as you did, Governor Healy and Lieutenant Governor Driscoll for their confidence in me in allowing me to continue to serve the residents of the Commonwealth. And I very much appreciate you suggesting that my career representing Melrose was a successful one. Perhaps you didn't talk to many of my former constituents in Melrose before you made that assertion, but I hope so. It has been a pleasure to serve in all the capacities I've been able to serve, and I'm looking forward to doing some good work with you all here. So thank you very much for the warm welcome.
Thank you, Commissioner. Commissioner Skinner, I see your mic's off.
I was just off to prepare for the minute vote, but I will take the opportunity to welcome Paul, Commissioner Broder, to this commission again. I had the opportunity to do that last week, and I am looking forward to working with you, and I'm looking forward to your contributions to this commission, this esteemed commission, as you rightfully acknowledge.
Thank you, Commissioner. I appreciate it.
No problem. Any other comments before we move forward? Commissioner O'Brien?
Just saying, my sort of official beyond an adjudicatory hearing hello to Paul. And I love the fact that the senior and junior members are hail from the Framingham District Court. So my stories to be told offline, but welcome, Paul. I'm glad you're here.
Thank you, Commissioner.
Eileen, I'm just happy not to be last in the roll call anymore.
With that, Commissioner Hill, anything to add?
Just welcome. I already talked to him privately, so said what I had to say to him privately, but welcome aboard. It's a great commission to be part of.
I agree with that. With that said, we're going to turn it over to Secretary Skinner. She's prepared. She prepared a lot of work for us, her and Judy.
Yeah.
So,
Sorry about that. Don't blame Judy. You can blame me for the 5 sets we have before us to vote on. Attendance at all 5 of the meetings is consistent in that the 4 of us were present and Commissioner Broder was not. So I'm going to take them in one motion, if that's okay. Any comments, edits to them? All right. I move that the commission approve the minutes from the August 17th, 2023, September 13th, 2023, September 18th, 2023, September 21st, 2023, and October 19th, 2023 meetings that are included in our packet, subject to any necessary corrections for typographical errors or other non-material matters.
Second.
All right, so second goes to Commissioner O'Brien. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Broder,
Abstain.
and I vote yes. 4 and 1 abstention. Those go by pretty quick, Commissioner Broder. I remember when I started, I had to abstain several meetings, but it goes by quick. Especially at the rate and that Commissioner Skinner is pushing these through, so we appreciate that work. We're now moving on to our administrative update. Good afternoon, ED Serpa.
Good afternoon, Mr. Chairman. Thank you very much. I do have a few updates for us today. But first, I also want to welcome, on behalf of all the staff here at the commission, our new commissioner, Commissioner Brodeur, for your first public meeting. Commissioner, I know I told you in our first meeting how eager I am for you to meet and work with the absolutely tremendous staff we have here at the commission. They are all subject matter expert, and every day they demonstrate a real commitment, a super commitment to the commission in helping us all work to fulfill our mission. So based on my own experience, I know they'll be an invaluable resource to you. And I encourage you to take advantage of it, to reach out to any staff member at any point in time on any topic. And I know you'll enjoy learning from them.
Rest assured, I already have. And the welcome and the onboarding is certainly a work in progress. But the staff has been terrific. I look forward to working with them more.
Oh, thank you. That being said, Mr. Chair, I just want to quickly remind the commissioners that next Thursday, November 14th, we have scheduled our next visit to a Community Mitigation Fund grantee. We plan to visit the Holyoke Community College Culinary Arts Institute in Holyoke, Mass. And during this visit, the commissioners and other attendees will separate into 3 groups, or tracks as we're calling them, to participate in independent briefings and tours. One of the tracks will highlight the community college's Work Ready 24 hospitality training program. A second will feature the Springfield Public Schools Ahead of the Game casino skills training program. And a third will highlight a few of Holyoke City sponsored projects that were directly supported by mitigation grants. The 3 tracks will include both sit-down briefings and one brief walking tour. And at the end of the meetings, we will convene together as one group and briefly thank our hosts. As usual, the community mitigation team and the communications team have put together a thoughtful and engaging event for us. And I believe we have Joe, Barry, Lily, and Tom on the call if you have any questions.
Thank you, ED Serpa. Commissioners, any questions for the team? Just a comment that I think they're going really, really well, and we've gotten a lot of good feedback on these.
Oh, thank you very much, and thanks to the team. And for the second update today, I'm going to turn it over to Research and Responsible Gaming Director Mark Vanderlinden, who, as requested by the Commission, is going to provide a brief overview of the federal Supporting Affordability and Fairness with Every Bet Act, commonly known as the Safe Bet Act. So, Mark, if you're ready, I'll turn it over to you.
Great. Thank you, Dean. Thank you, Chair Maynard and commissioners, and a special welcome to you, Commissioner Broder. We have a lot of work to do, and I really look forward to it. So yes, as Executive Director Serpa said, I'm going to provide an overview of the Supporting Affordability and Fairness with Every Bet Act, or Safe Bet Act, which is HR 9590. It was introduced by Representative Tonko of New York and Senator Blumenthal of Connecticut in September. The Safe Bet Act is intended to address public health implications and the legalization of sports betting across the country. The bill has been referred to House Committee on Energy and Commerce, the Committee on Natural Resources, and the Senate Committee on the Judiciary for consideration. And to my knowledge, no further action has taken place since that. Included in your packet is a memo that provides a legislative outline from Representative Tonko's office highlighting elements of the proposed legislation. I won't go into great detail of all of it, but I think that there are a few pieces that I'd just like to highlight for you. First is that it establishes a general nationwide prohibition on sports betting, except for the states that have an approved application from the Department of Justice and Attorney Generals. It requires that states offering sports betting programs meet minimum federal standards with the respect to advertising, to affordability, which largely puts limits on play activity. It provides guidance on artificial intelligence. It prohibits all proposition bets featuring college and amateur athletes. Not included in Senator Tonko's overview, but I think important to point out in this general section is a prohibition on sports wagering on events that have already commenced, I guess in-play betting. The bill also draws in the expertise of a number of different federal agencies, including the Substance Abuse and Mental Health Service Agency, the Surgeon General, and the CDC to provide a number of different types of reporting and tracking of sports betting behaviors. And then lastly, and I think of keen interest to our commission, is it authorizes a national self-exclusion list that would be managed by SAMHSA and based on reporting from each of the state's gambling regulatory entities. Now, again, this has been introduced and sent to the committees that I mentioned, but no further action that I'm aware of at this point. So that's it.
Commissioners, do we have any questions on this update?
I do have a question, Chair. First, thank you to Mark for pulling this together at my request. It certainly beats reading the 50 pages of text, which actually is nothing compared to the public meeting packets. Does Congress give the public an opportunity to comment on these bills? Now, I'm not suggesting that the commission should comment, but I am interested. I see Commissioner Hill nodding. I'm interested in any other comments that might have come in on this bill, particularly from sports wagering operators, if any.
I will turn to Commissioner Hill, who may have more information on that.
It would go through a public hearing process like any bill would. I have not followed it enough to know that if it's gone to committee yet or not with a public hearing. I would assume that since it's the end of the session and the end of the year, that it probably wouldn't be going anywhere, that we would probably take another look at this next year because I'm sure it will be refiled. And at that time, we can then follow the bill a little more closely to see if there will be a public hearing on it. But I would say at this point, I don't know exactly where the bill is in terms of the legislative process in Congress, but there will always be an opportunity for us to be able to give comment if we would like, or to hear what others have to say.
Commissioner Hill, just to follow up, when you say you're not sure whether the bill has gone to committee yet, do you mean the House and Senate committees, or do you mean like what we would call a conference committee here in
The House or Senate committees.
Okay, and so it looks like it has. And do you know generally whether the opportunity for the public to comment is before or after that happens?
It would go to committee and then they would set up an appointment or a date to hear the bill. And then that would be the opportunity for the public to be able to go and testify for or against the bill.
Thanks for that. And so
I don't know if that happened. I didn't follow it close enough, to be honest.
Yeah, neither did I. And so just a request to the team, if we could track that.
Sure.
along the way so that we are getting the opportunity to review any comments. I mean, it might not go anywhere. But if it does get past the stage that it's at now, I would be interested, as my fellow commissioners probably would be too, to see what comments come in. Thank you.
Mr. Chairman, if I may, real briefly, there's a little bit of a variation on the theme in that, unlike the general court here in Massachusetts, the Congress does not schedule a hearing on every bill. So there are it is not uncommon that a piece of legislation can die without hearing a peep about it. It might die at the end of the session without any action taking place. I think it's at the discretion of the chair and the majority party as to what actually gets brought forward for a hearing.
So Chair, just a comment, just a follow up. I just want to remind commissioners that we did start a conversation, or at least it was mentioned a while back, with Dean, the need for legislative staff. And with all due respect to Commissioner Hill's contribution in that area, I do think, and now yours, Commissioner Broder, I do think that we need to have in line for an upcoming discussion, or at least for consideration as we move towards, finalizing some open positions. I know Commissioner O'Brien talked about a deputy at one point, just throwing the legislative affairs person in the mix as we move forward with those staffing discussions.
Thank you, Commissioner Skinner. Thank you, Commissioner Broder, for your addition. ED Serpa, you've heard what the commission has to say. I think the day I walked in, I said, "Where's the ledge director?" And that was in 2022. I was informed there's not one here, and I know most agencies do have one, but there's some direction on that. Any other questions for Mark on this particular presentation? I really appreciated it, Mark, and I appreciate Commissioner Skinner for asking for an update publicly. Anything else?
Commissioner Skinner, we'll certainly do our best to keep track of this and provide an update if any further action with it.
And we appreciate that update. All right. Anything else, ED Serpa?
No, I'll take those comments and I'll do some follow-up on them. But as far as today's administrative update, that's it.
And the one other thing I would say is I think we all join Commissioner Skinner on, if there are public comments, we would like to see them. If they exist, we would like to see them. So
Yeah, we'll do some tracking on that. Yeah.
all right, thank you. I appreciate it. With that, we are going to go to the Chief of the Sports Wagering Division, Carrie Tracy. Hi, Carrie.
Yes. Hi, thank you. Good afternoon, Chair and Commissioners. So this first item from sports wagering, I'm going to turn it right over to Compliance and Operations Manager, Stefan.
Thanks, Carrie. Good afternoon, Commissioners. Just a quick item for me today. Beginning on page 66 of your packet, we provided a memo on an upcoming boxing match scheduled for next Friday, November 15, between Mike Tyson and Jake Paul, set to stream on Netflix. This event is sanctioned by the Texas Department of Licensing and Regulation, or the TDLR. The TDLR also falls under the umbrella of the Association of Boxing Commissions and Combative Sports, or ABC Boxing. ABC Boxing is an approved league in the boxing tab of our event catalog. And also a side note on the event catalog, in section 1 of our guidelines tab, we also allow exhibition matches on any approved league as well. So this event is allowed for wagering under our currently approved catalog. And before I get into why we're bringing this forward today, I did want to highlight 2 rule changes to this match that deviate from other boxing matches sanctioned by the TDLR. First, each participant will wear 14-ounce gloves as opposed to the normal 10-ounce gloves for their weight class. And second, the rounds will be limited to 2-minute rounds as opposed to 3 minutes per round. Both rule changes were agreed upon by both participants. Now, we wanted to bring this to your attention really due to the fact that many other jurisdictions reviewed this event before offering it. And what I mean is they reviewed this for the rule changes as well as any integrity issues. Most jurisdictions we contacted provided prompt responses stating they are allowing the fight for wagering. Some of the states, specifically those included in your memo, even provided detailed answers that they reviewed the event and the rule changes and saw no issues with continuing to allow it. However, 3 states in particular are not allowing the event. Colorado stated they have very specific guidelines they take into consideration and that any deviation from the approved rules will not be considered. Pennsylvania and Vermont both provided similar answers to each other, citing their decision was based off the deviation from the standard rules, with Pennsylvania even providing a little more on the integrity of the match due to the 31-year age gap between the 2 fighters. It is worth noting before I move on that these 3 states generally allow wagers on ABC boxing sanctioned fights. However, for the reasons they stated, they've elected to not allow this match for wagering in their states. One last interesting case is Nebraska, where this event would not be approved under their current catalog of offerings due to them deeming this as an exhibition match. However, they made the exception recently to permit the wagering on this event to dissuade their residents from wagering on the illegal markets. Final note here, we did reach out to 2 integrity monitoring services. Both entities stated in similar wording that it would be unlikely there would be any betting related corruption due to the significant public popularity and fight purses in the multiple millions for both fighters. That's all I have on this matter. I'd be happy to help answer any questions you may have. This is also marked up for a vote. However, the vote would be to prohibit and not allow this particular event. That is not our recommendation. However, after extensive research and connecting with other jurisdictions, as well as those integrity entities, it is our recommendation to let this event stand as approved for wagering. Chair.
Thank you, Andrew. Commissioner O'Brien, I see your mic off.
Yep. So I had the benefit, I reached out to Carrie and Andrew, had a more detailed conversation about this. The most influential factor for me in terms of not moving or seconding a motion to ban it is the changes appear to be trending towards safety and not away from it.
Yep.
Which was pretty influential for me. I have a deeper thing to raise with us as a commission, which is flagged for me by this and by the fact that some states do not allow exhibitions to go as a matter of course. We currently do. So I would like to say to sports wagering and the rest of us, we might want to consider whether we want to have parameters on that going forward. I am not concerned with this particular event today, but it did raise a question for me going forward, whether we need to have a deeper conversation about what this catch-all is and whether we might be inviting risk by not having that conversation.
Thank you, Commissioner O'Brien. Commissioner Hill?
Yes, Mr. Chairman. So I too reached out to Carrie and Andrew, and I thank you for putting up with my questions that I had. I too had some concerns when I heard about the rule changes, but once, as Commissioner O'Brien has stated, once I found out that actually changing the rules on the amount of time and the gloves that are being used, it's actually for safety reasons, which I thought was pretty good. Even have that conversation. So I have no problem just leaving things as is. It's part of our catalog. Our staff has done yeoman's work digging into it and looking at other jurisdictions and, reasons why they were for or against it. But in terms of Massachusetts, I see no reason not to allow this fight to move forward and to be able to bet on it.
Thank you, Commissioner Hill. Commissioner Skinner, I see your mic off.
So 3 for 3 so far. I too have not heard anything that would lead me to believe that this is not an event that the commission should continue to sanction. As Commissioner O'Brien said, the rules changes are trending towards safety and not the other way around. So that to me was very influential in my decision making here. The question that I have is, and I did have an opportunity to chat with Carrie about some of the perceived concerns outside of maybe the sports wagering regulatory industry. My question is whether any of the sports wagering operators' house rules would speak to rules changes for these kinds of matches, right? Should we be looking for anything in the house rules that would apply, or how do And I know the House rules are really around how the operators operate in terms of their wagers. But is there something in there that speaks to how they should treat commission rules or the regulatory, the entity that oversees the matches? Is there anything in the House rules that we should be looking towards that might apply here, that we should be that we may be concerned about?
Nothing that I've been able to find in the House rules, nothing that speaks to that particular section of that question. No.
Okay. Thank you.
Thank you, Commissioner Skinner. Commissioner Broder.
Super briefly, I support wagering on this fight, so I will not be bringing forward a motion.
Thank you. And so this makes it 5 for 5, Andrew. I will only note that we talk a lot about the illegal market and what drives folks to the illegal market. I think if we did ban this, especially as it falls currently under our rules today as approved, if we did ban it, we would only be potentially moving people in Massachusetts to the illegal market on this fight. And I would support, as Commissioner O'Brien said earlier, a more broader view of changes that could come to these types of events in the future. I'm interested in that. But in this particular event, on this particular day, I join my fellow commissioners on thinking that we should allow it to go forward. Do you have what you need, Andrew?
That's it for me. Thank you all.
Thank you. Carrie, I think we're turning back to you.
Yes, great. Thank you very much. So we also wanted to provide you today with an update on the DraftKings and BetMGM compliance with 205 CMR 257.034 related to data privacy. So just to give you sort of some background here on what this is about, 205 CMR 257.034 is a section of our data privacy regulations related to data sharing that requires operators to hash or encrypt confidential and personally identifiable information. It includes a provision that operators may request approval from the commission to use methods other than hashing and encrypting, as long as those methods are equally as protective of the data. DraftKings and BetMGM currently have waivers from this section in effect until November 15th. Over the summer, 4 of you will recall, and Commissioner Broder, this will be new for you. Over the summer, both of these operators came before the commission to request that approval of their sort of alternate methods and to walk through the methods that they were using. During that presentation, it became clear that the methods were very complex. And at that time, the commission asked our IT division to meet with the operators to review their methods and then to return to the commission to explain them a little more clearly and to make a recommendation to the commission as to whether to approve those methods. So our IT division did that, and in their review of the methods, they determined that the operators were actually misunderstanding the regulatory requirement. They were reading the regulation to apply to data both in storage and in transit, when in actuality, the reg only applies to data in transit. There are different parts of the regulation that relate to data in storage. So following IT's review, they were able to confirm that BetMGM and DraftKings are currently in compliance with this section of the regulation, and they don't need any alternate methods to be approved by the commission. As a result of those conversations as well, IT proposed some clarifications to the regulations, and those are on the agenda today for you to review with the legal department. So as far as those operators are concerned, there would be no additional action needed. Their waivers that are currently in effect would just run their course and expire next Friday. And I believe we have Christian and Kevin from IT on if you have any questions about their review.
Any questions, commissioners? I appreciate the explanation, Carrie.
I have a question.
Commissioner Skinner.
It's not about the team's review, but it's just out of curiosity. What language in the regulation specifically was misinterpreted? I mean, in other words, was it a true misinterpretation, or were we not clear enough that that we were talking about limited circumstance here?
Yeah, so the issue, my understanding, and this came from IT, is that the term data sharing has specific meaning in sort of the IT world that would maybe have a different meaning in sort of the legal world. So that section is called data sharing. And, legal and when we worked with NK, we viewed that as, of course, sharing data. You're sharing it with another entity, but it has sort of a very specific meaning in the IT world. So that was where the misunderstanding came from.
Mhm. And the other question, I know there's a reference to consultation with the AG's office a while back when we contemplated some adjustments to the regulation. Was it necessary to do that this time around for this language? And if so, did we do that?
That would be a question for Justin, I think, when you get to the reg changes. I'm not sure, Justin.
Yeah, I can jump in. Commissioner Skinner, I sort of picked this up in mid-transit myself. So, but what we did with this one is these suggestions were made by our IT department, by our CTO, and I believe both Kevin and Christian are familiar with the changes. We did not go back to the AG's office on this one. The clarifications, as I understand them, that were made and are presented in the regulation redlined for you today are consistent with industry best practices from an information security perspective. So we did not run them by the AG's office, though. These were solely through our IT department.
Mm-hmm. Thank you.
I'll just add one thing. I don't think they make any substantive changes. The rules remain the same. They're just clarification to the language.
Yeah, that's a good point. That's a good point, Carrie. Yeah, basically in this, we can sort of dovetail right into the legal presentation here because Carrie provided everyone the background, which is also in the memorandum that legal submitted here. But the changes that were added by the IT department in the red lines really sort of distinguish the protections around data in transit versus data at rest. And according to what Katrina had informed us via her notes, and I know she's currently out, was that these were consistent with the IT best standards in a variety of different parts of the information security industry. And Kevin and Christian are both on the call if there's specific questions about any element of that, because it's a little bit beyond my technical depth.
Well, I know we're going to walk through the specific proposed amendments, but as we do that, I want to get on the record that I, for one, because we've had such a steady partnership and ongoing discussion with the Attorney General's office, I would feel better if we consulted them on these changes. I know you're deeming them more of clarification of the regs. However, if there was room for the sports wagering operators to misinterpret what we intended by the language, I wonder if the Attorney General's office, the folks that reviewed the regulation, was under the same interpretation, had the same interpretation, and therefore is now, if we are going to vote to change it, I just would want to understand whether they had any concerns.
So one moment. Can we take a pause for 1 second? Can we, Commission, I just want to keep a clean record. So we're under item 4B. Are we good with the update from Carrie? This is related, so we'll put that in the parking lot, Commissioner Skinner. Are we good with the update regarding BetMGM and DraftKings that Carrie gave us before we turn to 5A, which is going to be, I think, directly in this conversation? I know Mina's wanting to weigh in. Are we good with the update we received from Carrie as to that issue?
Yes.
All right. Okay. I'm seeing yeses. Commissioner Skinner?
Just a clarifying question. The waiver that was extended to those two operators, I think Carrie said expires Friday. Is that tomorrow?
It expires the 15th, but because they're in compliance, it wouldn't have any impact on, if you decide not to move forward with the reg today, that wouldn't have any impact on those two operators. They no longer need a waiver.
They're in compliance with the regulation as it's written currently.
Exactly. Yep.
Thank you. Okay. I have no issue with the update, and I have no issue. Thank you.
Thank you. All right. So I'm seeing yeses across the board. Commissioner Broder, are you good with that too? Okay. So what we'll do is we will turn to the next topic, and that is 5A, and that's a review of 205 CMR 257. We do have Councilor Grossman, and we have Councilor Stimpik, and I also see Mina from A&K. And so with that, I'll turn it over to legal, but let's go ahead and start where we just ended in that related conversation, if possible.
Yeah, I think Mina was going to offer some clarification, so I'll turn to him. Go ahead, Mina, if you want to add.
Thank you.
Yeah. Good afternoon, everyone, and thank you for the chance to weigh in on this. Just on the portion regarding the Attorney General's office, while I certainly have, that's certainly up to the commission whether to consult further in this round. This issue, when it had come up, and just as a reminder, sort of through the waiver process, the AG's office was involved and aware of the waivers happening. They were also involved of the changes we were making and the conversations with the operators at the time. This, I know this is now a clarification from the IT staff on sort of making sure everyone understands it the same way, but this question of the degree of hashing and ability to access the data when at rest or within the sort of, not when it's going between.
Mina, was that all you had? You cut out. Well, let's try to someone get Mina back on the line here, if possible. I did understand his point, though, and I did have a memory of this when we discussed this last time, that the AG's office was involved in the overall substantive issue, and that we really were in an interpretation issue, and that perhaps my memory was a couple licensees were interpreting this really, really strictly versus others. With that said, I'm going to kick it back to you, Justin.
So the context I was providing by way of what I said earlier, I mean, Carrie provided the background on sort of how we got to this particular spot. What then occurred was our IT department, after meeting with those operators at the tail end of the summer, realized that it was a misunderstanding. And then Katrina and her team went into the regulation and made the suggested red lines that appear before you today. And those are in the 256.04.3 subsection. We added a new section 4, sorry, and then we just renumbered it to 5. So to make a clarification concerning the protections surrounding data at rest versus data in transit. And my understanding from Katrina's comments on this, that this is all consistent with the industry best practices in IT sphere. And if there's any additional sort of questions or commentary about what those are and what those mean, we have members of our IT team on the call today to provide further clarification on that front.
And Mina, did you have anything to finish? Thank you.
I apologize. It's always a little embarrassing to get logged off when you're talking about IT issues at the same time. I don't know exactly where I cut off, but my only point was that these changes, based on my conversations with the AG's office way back when we were talking about the waivers and the reasons for the waivers, are consistent with what I recall being their understanding of what was going to happen, that it was means to protect from unauthorized access to data was their big concern, and that's what this is intended to do in the right language for IT professionals to understand.
Mr. Skinner, is that addressing some of your question?
Yeah, moreover, thank you, Mina. As you alluded to in your opening remarks, this is the first round, right? So these are not being adopted if the commission chooses to do that by emergency, right? So they are going out, the changes are going out for public comment, yes?
That's correct, Commissioner Skinner. This would just be the start of the promulgation process. So we'd have public comment, we would receive commentary, it would all come back before the commission.
Yep. My request then is that these be sent directly to the AG's office as an FYI, and or, for them to have an opportunity to comment.
I can absolutely send a copy over to our contacts at the AG's office.
That's a really good solution, Commissioner Skinner. All right. So are we going to walk through the changes too? I know we kind of jumped in the conversation head first, but
I mean, the changes are as they appear in the packet. They're fairly technical. If there's specific questions about them, I would likely defer to Kevin Gavro, who's on the call with us, if you have any specific questions about what these are. But my understanding is that these, or what Katrina had informed me, that these were consistent with GOI 33, the World Lottery Association, and ISO 2701, which is a international standard for data privacy and protection.
thank you, Justin. So with that, Kevin, I am a self-proclaimed Luddite. I have said that in multiple meetings. Is there a way that you can explain these changes to the commission that even a Luddite like myself could understand?
Yes, Chair. Really, it's just dividing number 4 into 2 items so that it is clear that what needs to be done when data is stored in a file format or a database versus when it is being transmitted over the network to like a third party, like a GeoComply or other vendor that they work with. And it's just defining the 2 as separate items, whereas originally it kind of was hard to tell if it was talking about when the data was stored or when the data was in transit.
I actually did understand that, so I appreciate that. I'm shocked. Commissioners, any questions for Kevin or Justin on these changes before they go out for review and comment? All right. Well, we do have this marked up.
Mr. Chairman? Oh, I'm sorry, Commissioner Skinner had her microphone off. Mr. Chairman, I move that the commission approve the small business impact statement and the draft of 205 CMR 257 as included in the commissioner's packet and discussed here today, and further that the staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth to begin the regulation promulgation process.
Second.
Thank you. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Broder, and I vote yes, 5-0. All right. I believe we are sticking with the legal team, Todd.
It's still with me, Chair. So,
Thank you.
This is another regulatory revision and for you on the letter of credit regulations at 238.12. Commissioners may recall there was 2x2s held presenting a variety of different options here with respect to the letters of credit. This was certainly a team effort by staff, including CFAO Lennon, Carrie Teresi, before she moved to sports wagering, was really spearheading this initiative as well. And Mina from A&K is well versed in all of these issues. So I'll turn it to him just to provide a little bit more color on the decision to make today. Thanks, Mina.
Yeah, hello again, everyone. So this set of changes, just to kind of walk through where we started and why we're here, I think is helpful, at least in the short summary form. 238.12 initially came before you as part of changes we made, the commission made, to address potential cessation of operations by operators that was being contemplated, or there was at least concerns about in the Commonwealth. If you recall, at the time we had consulted with Bankruptcy Counsel on behalf of the commission and tried to think of how, in the case of cessation, the commission could play a role in protecting patrons and their ability to retrieve monies that were essentially in play at the time. That was really the big focus, with the understanding that other funds would be either committed to, vendors and other creditors would be able to go through the bankruptcy process to address their needs and any outstanding amounts, and that patron accounts were supposed to be and would still continue to be under this, segregated out from other funds that operators hold. And although not guaranteed to be protected in bankruptcy, there was at least a separation from the normal course. I think we then had rounds of comments and on these, and I believe, and I'll defer to sports wagering and others, there were further conversations with operators about how they were complying or looking to comply with this. And, you know, with the benefit of additional time, the ability to look back at what makes sense now when thinking about backup, financial safeguards and financial backup that operators should hold for patrons or patron accounts. It at least caused us to think about raising again before the commission the issues of what would be most useful and what is the right level of support for patrons, and given that there are costs, of course, to asking this of operators. So that's sort of the preliminary part. And Justin and Carrie, I don't know if you want to weigh in then, or I can walk through sort of the different options.
I would just present the options, and I think given our prior conversations, that probably makes sense.
Yeah. So the first option is sort of maintaining the current regulation. And I will refer folks to, this is page 84 of the packet, the red line, so you can see what it, this will be options 1 and 2, but option 1 without the red line, would be essentially to have patron wagers that are in play, money that's in play, outstanding amounts that have not been awarded, or that for events that have not occurred yet. For instance, someone bets on a future event and company goes out of business in between. Those would be protected by a letter of credit, which would be held by the commission, meaning that the commission could, in theory, at that point, if there is a need to, call on the letter of credit, have cash available, and pay those patrons. However, money in patron accounts, which money that's not in play, but that is being held on a sports wagering website, was not initially protected by a separate letter of credit, which risks it being swept into the bankruptcy estate, although it is not an absolute guarantee that it would. Bankruptcy law would typically recognize that it's a separate account, as I understand it. I am not a bankruptcy lawyer, but having consulted with bankruptcy counsel, but it would at least be arguable on both sides. So patrons may not be able to readily access that amounts that they stored essentially with a sports wagering operator. So that's sort of option 1, is to leave as is the regulation. The second option, which you see presented in the red lines, in the first set of red lines, would be to broaden the letter of credit requirement. This is, I would say, the most protective in a sense, but also the most expensive. The irrevocable letter of credit would apply to both the operators, the amounts that patrons, have sitting in their accounts, as well as the amounts they have in play and the amounts that they have that are sort of outstanding and not yet paid out. That has the greatest expense to it for operators. It also would, require sort of adjusting that the letter of credit has to be adjusted quarterly anyway under the way that currently is written, but obviously this would add sort of another set of funds that it would account for. And this is the most protective in bankruptcy, but again, the most expensive. A third version is to sort of flip it, to worry less about or not have a guarantee for money in play, but have a guarantee for amounts in accounts, essentially trying to to protect better than bankruptcy code does on its own patron accounts, liquidity in bankruptcy, so that the commission could use a letter of credit to pay those out. But then bets and wagers that are made essentially would be made with the risk that the company does not stay in business. Some of the reasons we're revisiting this, as I mentioned at the outset, is one, there's sort of the benefit of time, the urgency of the concerns about cessation drove sort of the initial round of this. However, now several months to a year later, we are, I think there's less of that pending out there in the marketplace, although others can weigh in on that if they have more information. It is a reg that is unique to Massachusetts. We do not, there are plenty of other states that do have regs that require backup, financial backup. That's pretty standard, and that's why it was in the internal controls in the first place. However, not many have the same. I don't think any other one has a backup that is immediately liquid on bankruptcy. Again, that was driven by the cessation reg. So that is that's a very high level explanation of the three options. I will note a small thing. Regardless of what you do, there is a little bit of a typo, one letter typo in the spelling of commission, which resulted from the Secretary of State's office's transcription of this.
Thank you, Mina. Can I, if my commissioners will indulge me, can I ask a threshold question here, which is, to me, what you just said, at our current level, what we're doing right now is more protective of consumers than what most jurisdictions are doing today. Is that correct?
Your current reg, that's correct, is more protective. We are not aware that any other state has the letter of credit requirement to back up wagers in play and wagers that have not been awarded.
Okay, thank you. Commissioners, do we have any questions of Justin or Nina on this?
So I had a lot of questions on this in terms of like the question mark around bankruptcy, right? I mean, you can segregate the funds with good intentions all you want, but the reality is if there's secured creditors in front of you, that's probably not going to matter, right? So the segregated funds are sort of for naught. The question that I've been thinking about after I had the sit down with you guys is there any way our regs can be written in such a way as to essentially make those unused funds or wagered funds that status of secured creditor so that there's a prioritization during bankruptcy due to our regs?
Commissioner Bryan, it's a good question. Just to be clear, I think that's the issue of whether they get swept up into the bankruptcy estate is the issue to begin with. So the argument, as I understand it from bankruptcy counsel and in my conversations with them, creditors counsel on behalf of the patrons would certainly make the argument in the first instance they should not be used for secured creditors today, right? They're sort of accounts held in trust. They're not held for that. The only way to guarantee immediate access to them is to have them set aside in a separate instrument. And the
line of credit.
A line of credit or a bond or something else that is sort of accessible entirely outside of it. The reason for that is to the extent that the reg, anything you do by regulation would be preempted by the bankruptcy code on the federal level.
So that was my question. Is anything, we can't do anything in our regs that would sort of change the lineup when it goes into the bankruptcy process?
Correct. So for instance, if we wrote this as clearly as we wanted to and said, these shall be held in trust and under no circumstances may be commingled with a bankruptcy estate in bankruptcy.
That's for not.
That's cute, but we can't, you don't get to say that. So
okay.
Is that true of any financial instrument we might come up with, i.e. a letter of credit versus a bond versus something else? I'm wondering if a bond, and maybe it's as true of letters of credit as well, finance in some respect isn't my strong suit. But is there, I assume the answer is no based on what you've already said, but a bond that is specifically only reachable but cover that particular set of creditors?
Yeah.
Not a possibility.
So Commissioner Berdor, it's a good question. Both both a bond or a letter of credit would have a better protection than under the bankruptcy code. I think there's a sense that letters of credit tend to be a little bit easier because it sort of puts the bank in the position of then going to the operator and saying, we want our money back. Whereas with a bond, like an insurance policy, you know, the bond company has to be persuaded that it's time to.
I said that's an opportunity to sue, right? Is what we're talking
Right. But in both cases, they are separate from the bankruptcy estate because they're not being held by, they're being held by you, the commission, or by the Commonwealth, not by the estate that's going through the bankruptcy.
In terms of frequency of operator bankruptcy, what is the track record? Obviously, a couple of famous instances out of Atlantic City, but is this an exception, or is this something that, I mean, it's important because it obviously could happen, but how likely is it, or what's the track record of the industry in terms of this, you know, player being in jeopardy?
Yeah, I mean, I'll jump in here just briefly. Like this, I believe, and Carrie can correct me if I mistake the history here, but this stemmed out of we had 2 online operators that ceased operations in Massachusetts. So it wasn't a bankruptcy issue. It was more they wound up and ceased operations. Mm-hmm. So this is, I think the risk of a bankruptcy, I mean, while I think generally the existing operators in our Commonwealth we can look at their month-to-month revenues and reportings and see that they're generally quite healthy. So I don't think we have an imminent. This is really just I think a belt and suspenders approach, so that when or if there's another cessation and there's further mergers and acquisition in this space, what would happen to those funds if the worst case scenario occurred?
Yeah, it makes perfect sense. Thank you.
And I want to add, those were successful to the patrons, Commissioner Broder. Those 2 line ones. Commissioner Skinner, I see your mic is on.
So I want to make sure I understand the current landscape as put in play by our regulations. We require a letter of credit for wagers in play and wagers that have not been decided, or wagers on events that haven't been decided yet, but not for patron accounts. Correct?
Correct.
And even in that, Massachusetts is more protective than any other jurisdiction.
That's my understanding. Yeah, that's
okay.
Has done that.
Okay. Have we heard from the operators here? I know, Nina, you talked a little bit about reasons for revisiting this regulation. It's been a while since we've promulgated it, and therefore received public comment, but I'm interested in what the operators are saying about what is currently the regulation, right? Because I just hesitate to go fiddling with the regulation without an understanding of what is driving such a necessity or at least a suggestion that the commission reviews without an understanding of what from the operator's perspective.
I can handle that a little, Nina. So I had called with all the operators to see that kind of prompted the waiver request, because as we moved forward, we saw that 0 operators had a line of credit established for this piece, which is why we brought forward the waiver. And when I asked about that, the question was, well, we have bonds in place. We're backing it with cash. If we have a boatload of cash, why are you worried about us ceasing or going bankrupt? So there was a lot of discussion around that. And we had to remind them, well, we are very consumer protective here in Massachusetts as well, which is why we have these restrictions. And, you know, I opined that if it were up to me, I would make them have a letter of credit on their patrons' deposits as well, because that usually exceeds what the liability is for the rest of it. So, you know, there was a lot of discussion on it. So no matter what you put in place here, unless you keep the reg as it is, we anticipate quite a few comments from the operators to let us know what they're doing and let us know why they would object and what the cost of these instruments are. And there was actually operators that came back to us with, can you provide us with the option of using a surety bond as well? Because that may be a little cheaper than the letter of credit. And that's why Mina took a look into the surety bond with bond counsel for us. So yes, the reason, the impetus for this is coming from the licensees. It's a fairly expensive instrument that we're asking them to take out. And they're saying, but we have a boatload of cash sitting here. Why do we then have to tie up the money, one, that we can't move around? And, we said, well, one, that's part of the statute, right? They have to be segregated accounts and it doesn't allow it to commingle. And they said, but then two, why are you asking us to take out an expensive financial vehicle as well to secure these funds? And we had to remind them that we are very patron focused here in Massachusetts. So that's the reason why it's coming back forward. Commissioner Skinner?
Thank you, Derek. Did you say that there are waivers?
There are
already
waivers in place for, yes. So we took this up at a meeting where we allowed waivers until I think it was a 90-day period, wasn't it, Mina? Until we could bring this back forward in front of the commission for the letter of credit.
So I missed that we currently have waivers for this regulation. If I missed that in the memo, my apologies. So could we just get clarity as to when the waiver expires? Because I think that's important information. And then also my question to you, Derek, or anyone who can answer is, how much of the expense of these letters really is just the cost of doing business? Right.
Well, that's what we look at it, right? We look at it as that's the cost of doing business in Massachusetts, and that's the way our regs are written. But they will say we're an outlier, as Mina pointed out. We are not the only, we are the only jurisdiction requiring this.
Mm-hmm.
A lot of them are only requiring a cash reserve or a cash reserve with a multiplier on top of it, like 110%.
Okay, and sorry, and is that deemed generally adequate protection for a patron for their accounts as well as their wagers and what's outstanding in terms of determining a winner, right? Like
So that's another thing that they'll comment on, Commissioner Skinner. You're heading down the right path, which is why a lot of people have a problem with this regulation. They're saying that our 110% in a look back at the quarter old is not a good thing, right? Because if you're going into football season, that 110% reserve isn't enough to cover your liabilities because football bets are going to go way up. If you are going out of football season and you're hitting a slump, you have way too much sitting aside in your cash reserve or in your letter of credits. So we anticipate getting comments on that as well. What our amount that we're asking to hold and even the cash reserve liabilities are, or our total liability reserve. We had very extensive conversations, and this reg, while written with its best intentions, is not necessarily coming out the way that would make it easy for an operator to follow or make sense from what we have written. And we knew this would happen when we wrote the regs. And this is good that we're getting feedback from the operators. Not good that none of them have a letter of credit open currently, but with their financial pictures, it's not a huge issue, which is why we did authorize a waiver.
Okay, thank you for that. I mean, I'll stop there, but I will renew my request to have someone speak to the current waivers that are out there. It looks like Carrie is trying to pull up some information. So if you need more time, that's fine with me.
Yeah, sorry, I don't have the answer to that right now, but I am looking for you.
So one of the things that I sort of threw out there when I was getting briefed on this too, talking about that fluctuation in season and how much money might be at risk, that sort of thing, whether we might have to have a multi-pronged approach to this in terms of protecting consumers. And one of them might be looking at other regs in terms of how much the money sits in the account and whether we want them to be notifying people. Maybe they can motivate them to draw down their balance so we're not risking as much sitting there. I know at 3 years with no action, they get noticed as getting kicked over to abandoned property, but maybe we want them to be more proactive with letting people know they've got money in there. then they can decide to take it out if they need to, rather than have it sit. So something else that I think we should put in the arsenal in terms of our conversation and protecting consumers is maybe putting that in a reg, requiring that to happen.
If I could just jump in for one moment. Andrew did check for me, and the expiration date for the waivers is March 1st of 2025.
Thank you. And it applies to all operators.
I believe so.
It does. As I recall, there were a few that we had to get on board with it because they thought that their cash reserves were enough, but it does apply to all operators. I think with the exception, oh no, it does apply to even the category ones because they do have outstanding liabilities. They just don't have patron accounts. It's the brick and mortar. Apologize.
And the waiver is from our current reg today.
In its
Right.
entirety, it'd be entire, that entire 238.12. So could you clarify? Is it just the labor?
It was a letter of credit section, Commissioner Skinner. We did
Okay.
say you still have to have the 110% reserve.
Okay, thank you.
Quick
Can I ask
question.
another question? Oh, sorry, go ahead.
No, go ahead. Go ahead, Commissioner.
Commissioner Skinner and then Commissioner Broder.
So this just 238.124 talks about a monthly attestation that funds have been safeguarded in accordance with this regulation. Are we currently receiving that? And I think.
Yes, we are. And they are footnoting on it that they have a waiver from the letter of credit section.
Got it. Okay. Okay, thank you.
Commissioner Broder, thank you.
So,
Commissioners.
quick question, and might be born out of ignorance. Do we have a sense of, is there an average amount that a player has in an account that's not encumbered by a bet? Say, is there, is the average person sitting on $2,000, $20,000, or is it all over the map? Or maybe we don't know.
I do not have that information. We could always ask the operators. It would probably vary by operator too.
And it might fluctuate so much, it's very hard to nail down, right? That's certainly a possibility too. Just curious.
And just, Paul, so you know, there is no max, right? We didn't cap it and say it under no circumstances shall it exceed 10 grand. So there is no reg that puts a cap on how big that balance can carry over.
Yikes, thank you.
Which is another thing I was thinking about. Like, do we want to do something like that so the risk of actual dollar loss is minimized?
Or at the very least, a notification once you hit a cap could
Right.
also be, yeah.
Right.
I hear you. Commissioner Hill.
Mr. Chairman, I'm thinking I might be in the minority here. I really don't see a downside to doing nothing. I think our current reg is fine.
So kind of leaving it as is.
As is. I think there is enough protection in there. And believe me, and my fellow commissioners know that how consumer protection. I think as currently written, I think we're okay. And by the way, I have the utmost respect, Derek, for you and obviously your staff and your opinions, and I do. But I think in this particular case, I think I just have to agree to disagree that we need to make any changes at this point. That's where I'm at right now with all the discussion that we've had. And I feel bad about that because usually I'm right on board with everybody and the recommendations. But in this particular instance, I just don't see what the downside is. I don't see a downside with leaving things as is.
Yeah,
That's where I'm at. That's where I'm at, Mr. Chairman.
And Commissioner Hill, I take no offense to that. So that's why all of you are in these appointed positions. It's to come from different points of view.
Yeah, I'm not sure, Commissioner Hill, that you are in the majority or the minority. I don't know. I don't think any commissioners really showed. I think given the position that we're in right now, and I think Derek actually pointed out, or Justin, one or the other, that we do see their numbers every month. And this is already higher protection for consumers than in the rest of the country. I'm probably thinking like you. I'm also thinking that if there's an opportunity for us to get more information or to think about this more, I'm okay moving this topic. I don't think that this topic is something that we're worried about happening today, as Mina pointed out. And so I would be okay thinking about this a little more if we want time to think about it. So I could go either way is where I'm coming from. So there, I showed my cards. Commissioners, thoughts? Commissioner Skinner?
Yeah, I certainly don't see a reason to be any less protective in what I've heard today from what we currently have on the books. If anything, I'd be open to expanding the protections for consumers to include the money that they have sitting in the accounts. And, you know, Commissioner Broder, I think, started to go down this line of questioning around, you know, what are the amounts, the average amounts that people have sitting in their accounts? I mean, and if we can't protect both the accounts, the money sitting in the account and the accounts, the money being wagered, whether it's better to protect the money sitting in the account than it is on the wagers, right? So I don't think I've heard enough to sway either way as to what's better. I just, you know, Chair, you talked about the numbers we receive from the operators monthly. It's kind of fragmented for me, right? And so what I would be looking for is, you know, a clearer picture of, you know, why we should do one option over the other, or leave the regulation as is. And that's not to say that staff, I don't appreciate your memo, but it's still kind of very much fragmented for me, and I'm not sure which way to go. And I could also benefit from some additional time to really consider the question.
One option we could consider, Commissioner Skinner, is putting this out for informal comment to the operators. So without promulgating anything, getting commentary back from them to sort of color this discussion at a future date. And then we can come back to the commission with weigh-in from the operators about what their perspective is. And that may help sort of put a finer point on some of the issues that they see. And
I would broaden that opportunity, though, Justin, and say, you know, I'm interested to hear what patrons and some of the folks that represent the patrons say too.
And consumer protection in the AG's office, right? They've seen other industries. They might have a better sense of what's out there and what the level of acceptable risk is.
I think that is a tremendous, what Justin said is a tremendous idea, because what I was thinking before he said that was, I would love to get formal responses from all the interested stakeholders, but it's my sense was the only way you could do that is put it out as a proposed reg, and then based on feedback, obviously we can take further steps to modify or reject or whatever the case may be. But if there is that opportunity for informal discussion, because what I would like to know, because I kind of inclined to agree with Commissioner Hill based on what I know right now, I'd like to hear about return on investment or cost benefit analysis, right? If we're putting a very, very significant obligation on the operators and getting this much additional consumer protection, I'm not sure that's a great way to operate. So more information from that perspective, I think, would be very helpful.
I couldn't have said it better myself, Commissioner Broder. Thank you.
I don't know, there might be parts of this too, and getting some of this feedback. I'm sitting here thinking, I think a lot of people might conceptualize if the money's sitting in their accounts, their money. Might not be getting interest, but it's their money. And they may be surprised to learn that that really might be in a revolving account that the company's actually using in terms of fluidity for their business. So I'm curious about the amounts that are currently in there, sort of what's your average, what's your mean, what's your medium, and maybe this needs to be cycling back to consumers in general. Now, that may cause a whole other, concern in operators if this is a fundamental part of their cash flow. I don't know. But that's another area I'd like to get feedback from, Justin, in terms of when you guys are talking to these people, and Carrie and Andrew, when you're involved in that, because there may be a solution that mitigates risk, but it may also pinch their cash flow. I don't know, because I'm not sure how much they use this for.
I agree, Commissioner O'Brien. We got to remember it's a balancing act in the statute, what's put on us commissioners, and we've got to try to balance this and get it right. I mean, obviously, if protecting consumers comes at a cost at shutting down the businesses here, we're sending consumers back into the illegal market, and that's definitely not something we want to do as a commission either. So it's a balancing act. Are we good, commissioners, with perhaps sending this back to the team and putting it back on the agenda at a later date?
Yes.
Yep.
Across the board?
Yes.
Thank you, Commissioner Broder, Commissioner Skinner. So let's do that. Let's go ahead and it will give me time to think about it more too. I've now learned my colleagues' perspectives, which has informed me. It always does. And so let me think about this. Commissioners, if I may, and first of all, do we need a break? I'm Paul saying he used 5 minutes, Commissioner Broder. So when we
You're gonna
come
have to
back,
get your endurance up, Paul.
I can hear him laughing from over here. Even
I've turned off my life.
so I would ask that we go out of order when we come back. I believe we have outside counsel who has another obligation under our update for the SEIU Local 888 agreement. So are we good with that, commissioners? When we come back, we're actually going to skip item C for now and go straight to item 9.
Sounds good.
All right. All right. Well, 1:25. We'll be back. All right, Connor, I think we can take the screen down. Give everyone a second to get back.
Sorry.
No, no problem. All right, I think we're all here. So this is a reconvening of the Massachusetts Gaming Commission. We are holding this meeting virtually, so we will do a roll call. Good afternoon again, Commissioner O'Brien.
I am here.
Good afternoon, Commissioner Hill.
I am here.
Good afternoon, Commissioner Skinner.
Good afternoon.
And good afternoon, Commissioner Broder.
I am here.
Great. I'm also here, obviously. And with that, we are tabling 5C and moving straight to item number 9. I'm going to kick that over to, I believe, Edie Serpa and Caitlin. I see Director Monahan.
Hello, good afternoon. So yes, we have further information for the commission related to union negotiations. And so because of that, we are requesting to go into executive session for this conversation. The language is of course set out in the agenda.
With that, I know Mr. Conley has a time constraint. I will go ahead and read the language into the record, and the commission can decide whether it wants to enter the session or not. The commission anticipates that it will meet in executive session in accordance with General Law, Chapter 30A, Section 21A3, to discuss strategy with respect to the collective bargaining of the SEIU Local 888 agreement, as discussion at an open meeting may have a detrimental effect on the bargaining position of the commission. Would we like to enter into executive session?
I move that the commission go into executive session for the reasons on the matter just stated by the chair.
Second. Brian, second. All right, Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Broder.
Yes, aye.
I vote yes. So 5-0. Are we going to be automatically moved? Yep, there we go. We will return to the public session. Connor, I believe we're starting there. Didn't even have to say it. Commissioner Skinner, Commissioner Hill, Commissioner O'Brien. All right, we just left an executive session discussing item number 9. We're now re-entering. Someone remind me, do we have to take a roll call when we re-enter? I don't think we do we?
No, I don't.
No. All right. We are now turning back to item number 5. And for that, I will kick it back over to Councilor Grossman, and I believe Councilor Borelli will also be joining us.
Yeah, thank you. Without much ado, excited to turn this one over to Autumn, who has led the charge in preparing this amendment, which pertains to the practice of law before the commission here. With that, we'll let Autumn take over. So without further ado, Autumn, the floor is yours.
Hi, good afternoon. So today I'm bringing forward a proposed amendment for 205 CMR 107 subsection 2. This is the regulation which governs professional practice before the commission. The commission, the legal department, received a question requesting clarification from an operator as to how this subsection would apply to in-house counsel who are barred in other jurisdictions. I'll actually start with the history. Right now, as it's currently written, the regulation requires attorneys from other jurisdictions to request leave to practice law before the commission, and that they're also required to represent the client concurrently with a local attorney they hire to co-chair. After looking into it a little bit, the Massachusetts Lawyers Rule of Professional Conduct, specifically Rule 5.5D, allows attorneys who are barred in other jurisdictions to provide legal services as in-house counsel to their employer, as long as their employer has a continuous presence in Massachusetts. The amendments today would incorporate that rule into the regulations and would allow in-house counsel for our licensees specifically to practice before the commission without having to first seek leave or hire an in-house counsel to co-chair the matter with them. I think that pretty much covers it. Are there any questions?
Thank you, Autumn. Commissioners. Commissioner O'Brien.
Hi, Autumn. Thank you for that. My question that I have when I'm looking at the language for continuous presence is, does that envision a continuous physical presence in some way rather than some of the sports wagering agencies that have sort of a consumer presence, but not a presence in terms of their C-suite at all? So that was my only hesitation in doing this, that I wasn't quite clear on what that phrase meant in terms of that circumstance.
Of course. When I read that and interpreted it, I believe that it was more thinking of a presence in the state, as in they avail themselves to the citizens of the Commonwealth, whereas their product is available, they do business, they just generally are available to the citizens and are present in Massachusetts. They're licensed by the commission, and that is a tie to the Commonwealth.
Okay. So is there any guidance, commentary, case law to that effect, or is that the interpretation of the continuous presence?
That was legal team's interpretation, but I could look into further if there's any additional case law that would describe that.
Yeah. I didn't know if you knew whether that relied on anything external that wasn't put in front of us, or it sounds like maybe unclear at this point.
Thank you, Commissioner O'Brien. Commissioner Skinner, I see your mic is off.
Good to see you, Autumn. Thanks for your presentation. I'm generally, I'm okay with the exception to the general rule here that you're proposing. Except I would like to, for these in-house attorneys, I would like to know whether they're in good standing in the jurisdiction that they're licensed in, and whether there are any disciplinary proceedings pending. And so I would suggest a slight tweak to the language as you have it here, and let me know when you're ready. And I can just read from my notes.
I'd be happy to do that. I will say in the red line, section 3A should cover the whether they're in good standing, and 3B should cover the whether there's disciplinary proceedings.
It does, but it doesn't require them to file a certificate, right?
Okay.
It doesn't require them to attest. So you don't need me to give you language in that regard. I'm happy to, if you'd like. But we might as well do it now since we're voting on the language, right? Mm-hmm. So I would suggest tweaking, and it might be helpful to pull it up, Chair. I don't know, but I'll just say what my thinking is here.
I have it pulled up, but if we need to pull it back up, I'm sure someone can do that. I was actually sitting here thinking to myself, I was trying to think practically how this works, but I want to hear what you have to say before I try to figure it out.
Yeah, so towards the end of that first paragraph where it says appear and practice before the commission, provided that, I'm going to confuse myself for sure. I think we should move that paragraph C up there to go between the word provided and that, so that it would read, may appear and practice before the commission, provided that the attorney is an in-house counsel providing legal services on behalf of an entity licensed under GL Chapter 23K, 23N, or 128A, and the attorney files a certificate that, and then you have paragraph A and then paragraph B.
Just to be clear, Commissioner Skinner, do you want them to file a certificate every time they appear, or just?
That's what I was thinking.
Periodically?
I was thinking, is this something that is just registered once and we have it with update requirements? Or is this...
It's language that's taken from above. So what are they required to do for non-in-house counsel? I think this contemplates, or you tell me, I guess is my question.
Well,
are they required to do it each time, and in the first instance here?
You can have a generic notice of appearance form that, say if you're in-house out of state and not admitted to the Mass Bar, and it's just, we put the attestations in there, right? It makes it easy.
Yeah, I mean, this area of the regulations has not been stringently enforced over the years. We primarily do it if there's a hearing and somebody is going to be actively advancing an argument. Of course, as you all know, lawyers customarily and frequently appear before the commission for a variety of different reasons. Sometimes they're practicing law, sometimes they're just offering a factual background on a particular issue. So this was designed really just to carve in-house counsel out, who are sometimes straddling the line between practicing law and just advocating on behalf of their employer. So the answer to your question is, we do not and have not required in-house counsel to file these pro hoc vice petitions to appear generally. This was designed to kind of remove any question as to whether they should or shouldn't be doing that. So there is no present practice when it comes to those folks.
So put it this way then, whether in-house or not, the requirement of an attestation, I think I'd want it applicable to everyone that gets put through that process, and not just private counsel, right? Yeah. That's the point I'm making, and that's just me as one commissioner.
I mean, the reg right now if you look down at 03.1 does require notice of appearance to be filed. And it lists out sort of the other things. So you could either incorporate it, Commissioner Skinner, what you said, or do you want to have a new sub 03, right? That says, you know, out-of-state in-house counsels shall take this form and spell it out.
That's what I
Yeah,
was
I'm
reading.
gonna
also.
defer to council. Sorry.
Sorry, Commissioner Skinner. I was, that's what I was reading earlier, Commissioner O'Brien, when we were talking, when I was trying to think how theoretically this works. And whether it's you file it once and then you update any information as you go, or if it's literally each time in each particular matter on behalf of each client.
Yeah, I mean, it's like practicing in a court. You go in, it's the first thing you do is fill out the notice of appearance. So each matter they're coming in on, you know, and you may have a number of different in-house counsel who come in for different areas of expertise. So it's nice to be clear too, well, who's appearing on what matter right now as counsel?
And also circumstances may change from one matter to another, right? Particularly when they're appearing before us, you know, a year or two or more, or even less apart. So in that regard, I mean, I like the idea of each time they appear, have them submit the attestation. Again, I don't know what we do for non-in-house counsel. You know, I don't know if we're enforcing that piece of the reg, at least. So
we just to be frank, we do not really enforce this area. The question did come up though, for these in-house counsel for the licensees, whether they needed to pro hoc in, and the answer was yes, you do. But the question is whether that really serves a beneficial purpose or not. And if we think it does, then we should require everyone to file appearances and all that.
And my question is, will we start to enforce that at this point, right? Because does it make a difference, right? Where I'm quibbling about language.
But also, as one commissioner, yeah, we should, because you don't know if there's going to be potential conflicts of interest that come up with an attorney representing multiple people. And I want to make sure that it's clear who's representing who on what matter. Now, the conflict is less of an issue on in-house, right? That's just the form for making sure that they're covered here. But I want to see 03.1 enforced because that may be relevant if there's some litigation that follows. So I don't want someone coming back and saying, well, I wasn't an attorney in that circumstance, but I did this, or they represented multiple licensees and I didn't feel like maybe I was getting unfettered and loyal advice. You know, I think we should be having them file it. And then if the filing for in-house is has a couple other lines averring to the requirements of the Mass Professional Rules, you know, which form are you in-house or not?
That's really what I was sitting here thinking. I was thinking, is it, you know, in line with the bar, with the BBO, with all the various stakeholders? I kind of would like to match it up to whatever's going on there because I know a lot of people practice under the one client rule. And so it's, you know, I know it's done a lot, but I just want to make sure that I don't want to add any, much like we talked about earlier with the financial statements or requirements. I don't want to add any burdens, but at the same time, I don't want to be out of line with what's going on at other agencies in the state. I know Jenna Hintoff just joined us from DOL. I'm wondering what happens at those boards and commissions. I don't want to put her on the spot, but yeah, I would want to, you know, I do agree that we should clarify this.
Okay, well, we can certainly, you know, have a closer look and make sure we're enforcing this more uniformly across the board and require notices of appearance and everything else that's discussed here. We can also, of course, make the adjustment to paragraph 3, Commissioner Skinner proposed. And yeah, I think we can just be more vigilant about this whole section going forward.
I do want to clarify that though, that section 3 provision with Commissioner Skinner, so I know what I'm agreeing to. Is it in line with 107.031? Or is it a separate requirement that would have to be filed each time, or would it have to be filed? You know, I'm Jordan Maynard, I'm representing company ABC. And I filed at one time with Councilor Grossman to go back to his first initial question. And then as I go separately from that, 107.031 would kick in and I would have to talk about particular matters. That's why I'm trying to figure out what we're doing.
I would prefer there to be a separate form in that circumstance, you know, because if people turn over and 4 years later somebody comes back and they haven't been here before, we're not going to know for sure what their status is, you know, and we don't want to put that on them to drum up the thing they sent in to us 3 years. I mean, if we have generic forms that we say this is the form, just, you know, plug in and sign it and send it to us, you either fall under your license in mass or you're, you know, into the other one. And then it's just relevant to the case each time. That's what I would think would be the easier way to do it.
Good follow up on a point the chair made. I think so. What is the, to a certain degree, like, what is the problem we're trying to solve? I'm wondering, is this generated by a single inquiry of an in-house counsel somewhere? Is it the status quo seems fairly manageable in this case, but I would want it to be fairly consistent across practice, so that the cannabis, MBTA, DOL, whatever the case, would all be essentially the same. So essentially there's no traps for the unwary, which can sometimes be a problem for folks that don't have the depth of practice in a particular area.
Yeah, this was, as Autumn already mentioned, this was kind of triggered by one inquiry we got as to whether this person needed to pursue this or not. And we told them that they did, but felt as though perhaps it wasn't serving any purpose. And so that's why we proposed this carve out. I think we're just kind of shedding light on this whole situation, and there seems to be an interest to enforce it a little bit more stringently.
And it's fair to say then that individual agencies, commissions do have the power, because the general rule is have to be admitted or pro acquiesce, right, as a general proposition. But we are empowered as a commission to essentially change that, to vary that for practice before us.
I don't think we're changing anything per se. I think what it comes down to, for me anyway, sometimes, as you come to see, is that sometimes it's not clear whether someone is practicing law or they are advocating a particular
lobbying
point.
could be,
like when you're in court, obviously you are practicing law, and it's very cut and dry that you need to file a notice of appearance and you need to be pro hoc in if you're from out of state. So I think that's a lot easier. It's a good question what some of the other agencies do. I don't know the answer to that question and how they handle it. At my last agency, we didn't really ever have people from out of state practicing, so it didn't really ever come up. And so I don't know the answer to that question. It's a good one.
I know for a fact, though, that Jenna Hentoff would know, because she was a prosecutor at probably the highest volume, one of the highest volume agencies in the state, where she had to look across counselors definitely from other states.
Yeah, sorry. Hi, hello, Chair. Hi, Commissioners. I can say at my last job at the Division of Occupational Licensure, as a prosecutor, we did require opposing counsels to file notices of appearance with the hearing officer. It was less common, though, in board meetings per se to see an attorney appear on someone's behalf, because if it was in connection with a disciplinary matter, it was before the hearing officer. So they didn't appear directly before the board necessarily. Normally we would see people appearing, on their own behalf in their professions. So
I wonder if maybe EEA or some of the energy regulatory bodies within Massachusetts, of which there are many, that seems like a place where there would be a lot of what we're talking about today, right? Where national and international entities have various levels of business before the various agencies around, rate setting, which is fairly bureaucratic, right? As opposed to policy making, which is more of a non-legal adversary role sometimes and how all that works. I'm just talking out loud here.
So I'm less concerned with having our regulation, this particular one on professional practice, be consistent with other agencies, but more focused on, because that's not the question that's before us, right? We don't have a request to overhaul these regulations or repeal them. I'm more focused on keeping the requirements between in-house counsel and private counsel consistent. And so to the extent that we are requiring private counsel to submit a certification, attesting, or attesting to the status in, that they're in good standing and that there are no disciplinary proceedings pending, I would like that to be applied to in-house counsel as well. Again, respecting and supporting the fact that we're trying to relax some of the rules with respect to in-house counsel. I think that's definitely the way to go. But I do think some of the issues we're concerned about in the private realm relative to good standing and disciplinary proceedings are also applicable to in-house counsel.
Thank you, Commissioner Skinner. I don't see this as a relaxation of it. I see it as more of a notification, if anything else, of what people's intent is. But I agree with you. All right.
Okay, so I want to be sure I understand where we are right now. Are we stepping this back and rethinking this, or are you comfortable moving forward with the proposal?
I think the ask was to come up with a way to have the certifications in either circumstance, and because the requirements might be slightly different, right? There might be an additional attestation required of identifying the jurisdiction that the out of mass lawyer is in. I mean, I don't know what you would need that to say, but I think you need to step it back and figure out the cleanest way to do that, maybe.
Okay.
Yeah.
Well, I guess we can withdraw this proposal for the moment and we'll go back and take a closer look at this.
Well, thank
And
you.
thank you, Otto.
Autumn.
I know. It's nice to see fresh faces coming and talking to us. Not that we don't love the people that are here a lot, but.
When I took out of turn, our other matter, I saw Autumn in the hallway and I said, I could tell you were so ready. And I just really deflated it. So sorry about that again, Autumn.
Thank you.
Thank you. All right. With that, I believe we are going to turn to item number 6. And that's the annual report. Good afternoon, Dr. Lightbound.
Good afternoon. This is our annual report for racing for 2023. And I won't read, page by page. I'll just hit some of the highlights. The licensing numbers for occupational licenses were very similar to the previous year, around 1,600. Again, that doesn't take into account anyone who took into purchased a 2 or 3 year license. So the actual number of licensees is a little bit higher than that. One thing that was interesting was in 2023, we had 18 adverse laboratory findings. 7 of those fell under what is called the controlled therapeutic medication list. Those are drugs that any veterinarian might use to treat a horse, similar to what might happen if you took your dog or cat to a veterinarian. There is a recognition within the industry that you do need to be able to treat horses if something happens, but we also don't want them to be racing with those drugs on board. So there are threshold levels for those drugs. It's all spelled out. We have those listed in our trainer's manual that the trainers can get online or at the track. I'm not sure why there were so many. Usually we have, maybe 5 to 7 in a year. Partway through the year, I did talk to the horsemen's group about it and kind of flagged our rulings are public information. They're published on USTA. We have a book at Plain Ridge that people can come look at, and we also post them down in the paddock. but I did talk to the Horsemen's Group. We really couldn't come up with any particular reason for it. Our lab was still the same. We've been using that lab since 2016. They have the two different accreditations, the federal ISO or the international ISO 17025, and then the Racing Medication and Testing Consortium accreditation. Sometimes when jurisdiction changes laboratories, they see an increase in positives. But again, we didn't change that. And we also didn't have any changes in our medication regs. The good news is so far this year, we're down to a more manageable 10 positives so far. So maybe that was just a blip. What was interesting was we always offer the trainers an opportunity to have a split sample done on any adverse finding. And last year we had 5 splits that were sent out to other labs. There's 4 split labs that we use that also have the same accreditation. And all of those were confirmed. So again, that's always nice to see for our lab. Let's see. The judges with their rulings and fines, those did go down a little bit. In 2022, they started an effort with the drivers to tighten up events on the track a little bit. And I think the numbers in 2023 reflect them adhering to those regulations a little more closely. And, you know, then I just like to thank all the folks that work for the Division of Racing. I have an enthusiastic, devoted group of folks that work with us, and they're very supportive. I'd also like to thank all the other MGC divisions. Almost every single one of them has some type of effect on our racing division, doing different things for us. So we really do appreciate that. We couldn't do it without the help of everybody else with Plainridge, with MGC. And of course, we get continued good relations with Plainridge when we see things that we want addressed. They're amenable to it, and a good working relationship with the horsemen as well. If anybody has any questions, I'm free to answer them. And if there are no questions, I'll turn it over to Chad and he'll go over the financials.
Commissioners. Commissioner Smith.
Just one. And I remember asking this when we reviewed the 2022 report last year, and there was a reasonable answer to it. But why are we a year behind here? So 2023, it's almost a year behind.
Yeah, to be honest, if we don't get it done before racing starts in April, it's really difficult to finish it. So to a certain extent, it's on me for not getting it done earlier. Chad and I always have good intentions of getting it done in, you know, by the April when we start racing of the following year, and we just didn't get to it. We are a small staffed division.
Understood. I didn't mean to put you on the spot. That is not the answer I recall from last year.
Oh, I don't remember what the answer was last year.
But okay. Thank you, Alex.
Okay, well, thank you, Alex.
Absolutely fine getting it after the racing season. I understand the constraints.
Commissioner Skinner, I think part of it was, right, they have to wait till 23 is completely finished before they can start working on it, right? So they can't really start working on it until kind of early 24. So it seems probably further behind than it really is when you look at the calendar like that.
Yep. Yep. And to Alex's point, the racing season starts right back up in April.
So, right.
I get it. Thank you.
Okay. Good afternoon, Chair and Commissioners. I'll just provide you with a brief summary of the division's financials and the parimutuel activity in the report. So beginning with revenue, tax, and fee receipts, last year the racing division collected almost $900,000 in commissions, $750,000 in assessments, and over $285,000 in association license fees. We also collected over $61,000 in license and badge fees, and just over $38,000 in penalties and fines. Total receipts for the division in 2023 was $2,034,189, which represents a year-over-year decrease of 4.8%. Moving on to parimutuel activity, the handle from our 8 ADW providers totaled over 183 million. The 2023 live racing handle at Plainridge hit the million mark, coming in at just over 1,113,000. And the export handle, which are wagers placed on live races held at Plainridge that are taken at other tracks, was almost 18 million. The on-track simulcast handle wagered at Plainridge, Raynham, and Suffolk came in at over 54 million. All told, the total handle for 2023 was 256,662,473. And just something to highlight here, in 2023, we did take on 2 more additional ADW providers, that being Caesars Racebook and DraftKings Racing. The handle from these combined with FanDuel Racing, which we took on in 2022, was close to 30 million or 16% of the total ADW handle. And lastly, we distributed over $18 million from the Racehorse Development Fund for purse accounts and funding to the state's horsemen and women. There was over $860,000 added to promotional and capital improvement trust funds. And I'm also happy to report that we distributed just over $937,000 in local aid. And that concludes my summary. If there's any questions.
Any questions for Chad? Chad,
All the numbers.
I think but you know what? You're so good at explaining them, so.
Well, thank you.
All right. Dr. Lightbound? Anything else to add?
No, that concludes our presentation.
All right. If there's nothing further, I believe we are going to turn it over to CFAO Lennon. Thank you, Dr. Lightbound. Thank you, Chad, for the presentation. I enjoyed reading through it. You sent it separately outside the packet, so I did have the opportunity to see it before it even made it to the packet. Thank you for sending that around, or Grace did one, send it to the commissioners. So we appreciate it.
Thank you.
Thank you.
Afternoon, commissioners. I'm joined by John Scully, and we're here to give a brief overview on procurement / contract delegated authority. In February of this year, we came to you with a rather long demonstration on what the life of a procurement and how you go about procuring goods and services in the Commonwealth. As a reminder, we did adopt 801 CMR 21 as well as OSD's best value procurement policies. I think it was in 2013 the commission adopted those, and it was as was reported in an annual report. And what we did not talk about during that day, because we ran out of time, was a delegated authority level that the commission would like to give to staff. John is going to walk through a quick overview as well as a quick overview of the memo, and then we will be available for questions, comments, discussion from the commission. One thing I do want to clarify is on the top of page 3 of the memo. A few people came to me and asked me, what do I mean when we talk about the dollar threshold? And at that portion, I'll just read directly from it. It says there are many different thresholds that have been presented to you, ranging from $1,500 all the way up to $0 additional oversight for statewide contracts. I should have just left out the dollar sign and said all the way up to $0 additional oversight for statewide contracts. So it's infinite. And John will go through each one of those, but I wanted to touch on that before John got to it. Because I have had a few questions on that sentence, and it was just, as you can see, it's a poorly written sentence on my part. So now I'll kick it back to John.
Thank you, Derek. Hello, commissioners and team. I'm following up on our procurement presentation from February 29th, 2024, to establish the commission's involvement in the procurement process triggered by delegated thresholds. As a reminder, the thresholds are as follows. This is what Derek was alluding to. The first threshold is procurements greater than 500,000. That's set by the Office of the State Comptroller. The next threshold would be 498,000. This is a World Trade Organization posting thresholds that is set in conjunction with Operational Services Division and the Office of the State Comptroller. They're part of that organization. And so any procurement that is posted over 498,000 needs a notice. The next thresholds, this is set by the Operational Services Division, and it's for large procurements. It's anything over 250,000 annually. In contrast, the small procurements are anything 250,000 and under annually, and that's also set by OSD, Operational Services Division. And then we have incidental purchases, which are really very small procurements. $10,000 is the threshold. That's set, by both the Operational Services Division and the Office of State Comptroller. And then we've got a de minimis purchase threshold that is set by the Commission of $1,500. And then lastly, as Derek had noted, for statewide contracts, there's no set thresholds on that. So I guess, going further along to summarize the memo, MGC conducts its procurements in a fair and transparent manner, consistent with OSD and OSC guidance. Since the Commission is responsible for approving the budget process and procurements directly impact this budget, the Commission may elect to be involved in some of the procurement activities. Procurement activities are as follows. Participation in RFR development, that's request for response, RFP is also another word for that, which includes the following, which are further detailed in the memo. The due diligence part of this, drafting the RFR, the scope of it, reviewing the responses we get from any bid posting that we put up, and negotiating, and awarding any contracts, the results from those reviews. Also, in relation to statewide contracts, this is slightly different, but if the Commission elects to participate in statewide contract purchases, these are master blanket agreements that are off of pre-existing contracts awarded by the Operational Services Division or any of its delegated departments. And the thinking on that would be, participation in drafting the solicitation for quotes, determining any scoring criteria for any quotes received, and negotiating any terms or awarding any quotes. In conclusion, if the Commission decides to establish a dollar threshold for review by the 5 members, the process would be very similar to the delegated hiring authority. Staff would present at a Commission meeting that we anticipate moving forward with the procurement. Due to the anticipated spending level of the procurement, it has triggered the Commission's delegated procurement authority process. We would give a brief overview of what we are looking to procure, as well as a type of procurement. It would be a statewide contract, RFR, emergency, or otherwise. At this point, the Commission would discuss whether they want to be involved in that procurement and at what level, have commissioners participate in the review or the procurement team, or just be updated on the procurement and establish a cadence for updates. Thank you.
Thank you, John. I have to ask, did you put together this slideshow? That's in there? It looks really good. That's why I'm asking.
Yeah, so that the procurement presentation was put together by the finance team, and it really summarizes the state's process, and we did put it together.
It's really good. Share that with the team. if they're not tuned in. Commissioners.
Mr. Chairman.
Commissioner Hill.
Just for clarification, so as of today, is there a setting of a procurement delegated authority threshold here now?
There is none. As of today, the commission just approves a budget as long as the funding for that procurement is included in the budget. And, you know, our budget is very transparent, it's almost like line item detail. If we're adding something new, we say this is what it's for, almost to the contract level. So you do have knowledge of that. But as I said in the memo, and as John pointed out in the memo, there's no natural jumping off point for us to say, and this is the same thing that came up with hiring. There's no natural jumping off point to say, hey, you approved this, but now we're going to move forward and actually start procuring these services. And this was kind of the impetus for the training on procurements. So no, we don't have one. We just follow what the state comptrollers and OSD have set for different thresholds to make sure that we're adhering to 801 CMR 21 or the World Trade Organization or state finance law or anything else. But the commission doesn't really have a point to say, I'd like to be part of that procurement. The commission.
Mr. Chairman.
Commissioner Hill.
So to be clear, when we're debating our budget, each department comes before us and they tell us what we think is going to be procured. So I look at responsible gaming, for example, when we're going to be putting out our reports and RFPs for those reports. We know at the budget hearing that that's going to happen throughout the year, and we're given pretty much how much it's going to cost. As it would be with IT, if there's going to be a big purchase, we're told about it at that point, and then our staff moves forward throughout the year to procure that big ticket item. So what's being asked of us today is, do we want to be part of procuring that project either through a subcommittee or through an individual on the commission? What are we being asked for exactly if we so choose to move forward?
So what we're asking you is, one, do you want to set a dollar threshold for that? And then two, once that dollar threshold is set, we would bring it in front of you and give you that option. Do you want to be on the committee? Do you want to be a voting member on the committee? Do you want to be a non-voting member on the committee? Do you want to be a reviewer? Or do you want us to just come forward and give you updates? And each procurement will be different, right? But the first thing we're asking you to do is, do you want to set a threshold for us to come forward? And the threshold would be identified by these, well, I would advise that you choose one of these thresholds that other oversight agencies have set. 250, 500. You can always go below one of those, and I've had that at some agencies, but I wouldn't recommend it because oversight agencies are already comfortable with that level.
So where I am at right now is we have a process put into place where we know what is going to be procured. That process is through the budget process. When those are being procured, we are then given updates, more or less, throughout the year that, hey, we are moving forward with this. Certainly through the RG, we are given updates. IT has updated us, and Derek, through your quarterly updates, you have let us know. So I guess I'm trying to understand why we would be changing the process that we currently have, which I think works well. Because you update us on all procurements during your updates, or a lot of them.
I can speak to that, Commissioner Hill, from my perspective, and I've got sort of two questions and comments. And one is, Derek, your comment about the numbers. My experience, obviously, coming from the IG's office under 30B, 50 and 100,000 are thresholds that are used quite often at the municipal level. And so those are the number of thresholds that I'm used to hearing and having, that those are the jumping off points for me, not 10 up to 250. So if we're talking about it, I'd be looking at 50 or 100, and I'd want to have a conversation with you guys about kind of numbers, like how invasive is this to you, right? To getting the budget going and just keeping the trains running. But there's another side to this too, Commissioner Hill, which is how often we're doing these procurements has varied in my time here. And so there have been times when someone made a comment to me that said, well, we're just going to keep it with them. We're going to extend. I'm like, you can't do that. Better practices at the 5-year mark, you got to put the procurement on again. Now, you may not get anybody else but that vendor, but you still have to go through the process. We also have some where, you know, the legal department, let's say, right? You may see a budget item that says X for outside counsel on generic questions on employment, on HR. They don't necessarily go into the nitty gritty about exactly which vendors are there and how often it's procured and what the status is and the length of that relationship. And so to me, when you're talking about that, I do want a threshold, and I'd like some sort of discussion about which ones are coming up for procurement, right? That might be another thing, that maybe it's not quite at a threshold, but maybe someone has an interest in that area, an RG research topic or outside counsel. So I would like to have a conversation about thresholds. And I think for me, it falls somewhere between that 10 and 250, Derek. For me, it's 50 or 100. One that's probably not, I don't want to be invasive in getting in the way of staff, but I do think as a commission, the work of the commission in terms of who are using vendors, how frequently is it going over, is something I think we should have a discussion about whether we want to be involved in or give the blessing and say, go ahead on this one without us.
So I'm sorry, Mr. Chairman. And Derek, go ahead.
That's all right. I was just going to address the 50 and 100. So it started off when I started in state government 24 years ago, that the 50,000 was the large procurement delegation level.
And then they ended it
and
in
then
like
it grew up to 100, I think.
Yeah.
And now OSD has actually increased it to 250 just because of the volume of contracts that would have to use, and theirs is for which template you're using, right? Which RFR template, and how involved it is to fill out, and how hard it is for vendors to respond to that.
Right.
That's why they
10 is the 3 bids. The 50 is to have to do the RFR process. That's the threshold I'm talking about. I'm not interested in the ones where you guys go out and just get 3 written bids to get something moving. That's not what I'm interested in. I'm interested in when you're actually putting out RFRs. And not necessarily the entry level to that, but you know, the next step up.
Yeah, and we can always go that level, right? But we buy so many things off of statewide contract now that also require us to solicit multiple quotes, and they're rather involved now. It's not like you can just pick up the phone anymore. Each OSD has come up with a contract user guide, and you actually have to develop the scope to ask for those services, because they've kind of slimmed down the number of contracts they have and offered a lot more services on those contracts. So now you have to really write up your scope of what you're looking for. I was not ready for the 50 to 100, but I can do that. You know, when I look at the number of RFRs we have that we would be looking at, you know, if we use the 500 threshold, it would be 23. And when you look at, so I do want to clear up a few things too that you pointed out, that we said we'd just be extending. We can't just extend off of an RFR. We have to put a start and end date.
But some of the contracts were in there, and then the idea of just renegotiate. This is a live experience that I've had of people suggesting they would just do another 5-year contract with extensions on it. And I had to have a conversation. This is a while ago, basically saying you have to procure it again. You can't just enter into negotiations for a new contract.
Correct. So you have to put on the bid that there are extensions available or not, and how long those extensions go for. And you don't have to exercise those. The first term you have to complete unless there's a problem with the actual vendor. And then you can terminate that relationship with the vendor and jump off. Statewide contracts are a little different, where you could negotiate with the current vendor if you said it's the best value and they're on the new statewide contract, which is why I'm saying you don't want to just do RFRs, because then you're losing some of that ability that you're talking about, Commissioner O'Brien, where we could just say, well, it's the best value for us to jump on with this new vendor. So that's why I was saying we should probably keep it consistent across both RFRs and statewide contracts based on the feedback that started this conversation back in February. That commissioners did want to be included in that. Now, we do have a list of the contracts that are expiring and need to be RFR'd that we can do each year as part of the budget process, right? Here's what the procurements that are coming up throughout this year. And do you want to be a part of it? Or here's a contract that is naturally ending, but there are options to renew. Would you like to be part of the evaluation to renew it? Or here's something that was procured off of statewide contract. That contract is ending right now. And do you want to be part of the negotiations to either use the same vendor that's on the new contract because it's already been procured and we've decided that's best value, or put it back out to bid or quote, using the new list of vendors on this contract.
So we did talk about this last time. I think Commissioner Skinner was the one that kind of flagged that it would be helpful for us to sort of see that rolling. This is what's coming up for our re-procurement. And so as part of this conversation, I do think that's helpful as part of the budget process, because we can set a threshold that captures that 23 or maybe the next tier down. But it still would be helpful, I think, for the five of us to hear what's coming up. And if someone has a particular interest, to say, yeah, I know it's not quite at the threshold, but I would like to participate in that one.
Yeah, and the 250 would not be a problem because once again, that's only adding 10 more contracts to it, right? So if you're looking at a 3 or 4 year renewal cycle, you're only doing on average 8 a year. Now, a lot of marks expire at the same time, which drives John crazy because last year he was doing probably about 15 RFRs. But now we're in a kind of lull phase, except for the new contracts that have come forward. So it's not like you're going to have 33 in 1 year. That's one of the things I pointed out. Now, if you drop it down to 100, that list grows substantially.
Right. So that's good for me to know, because in my mind, I'm looking in that range. But to me, then that gets me to 250, because it's like, well, I don't want to be doing this constantly and bogging the agenda down with that level every year. But the idea that maybe 8 a year are going to come in front of us at a 250 threshold, I'm comfortable with that. And with the expectation that there's sort of as part of the budget update you guys give us, you give us the heads up on this is what's coming up.
I think that would be helpful, Mr. Chairman. And would alleviate a lot of this.
No, I would hate to hear the number if we used 50,000. If Derek couldn't pull it out right away, I would hate. It means he's still counting.
It's a lot. Yeah,
I'm sure.
But
I just did it more like there are other thresholds and other statutory procurement things that don't jump from 10 to 250.
Correct.
I'm not suggesting we drop below the 250 based on what you said though, Derek.
Thank you. Commissioner Skinner.
So I'm fair. Go ahead. Sorry, Chair.
Waited patiently.
You noticed. It's a work in progress. I'm fairly aligned here with Commissioner Hill. I would not want to unnecessarily bog down the team as they procure these goods and services, which is a very specialized process. I mean, I spent some time doing it in my former life as GC or overseeing the procurement process. I don't consider it something that I would like to do today. And so I would hate to take away administrative oversight of the procurement process from the CFAO, from the finance division, our procurement team, who are very well capable of applying and adhering to all of the rules that govern this space. I'm satisfied that in addition to our own team, we have OSD who provides a level of oversight. We have the Comptroller's Office who provides a level of oversight. If it makes, so I'm not willing to step in for an additional layer of oversight. I think it makes sense, given that we do approve the budget, just in that process, knowing what's coming is enough for me, with a heads up that, you know, this is going out to procurement, whatever it might be, anything that we've budgeted for, particularly those bigger projects. For instance, the licensing management system. I don't know how I got involved in that procurement. I've been a non-voting participant in those discussions. And to be honest, how frequently I attend those meetings really just depends on the commission's schedule. So I have not been consistent in those, but I can attest to having the ability to step into those meetings or call our licensing division chief for an update if I so choose. So I'm comfortable in keeping that process. I think if it makes my fellow commissioners feel better, I'm happy to talk about whether we want to lower the threshold for when a procurement is required. I think that's a better way for me to want to go. We're talking about limiting the number of extensions and length of extensions that we're agreeing to as part of these contracts that result from a procurement. I think that should be put on the table, but I don't want to take the responsibility away from the folks that we have in place to do that particular, to do those particular tasks. It's an important function, and I think we've got the right people today managing those processes.
Thank you. Commissioner Broder.
I could speak for a long time or a short time, so I'm going to go with the short time. Ditto. Because I'm new, I'm not sure what the problem is that we're trying to solve. If there is one, I do know. When I was an acting GC, had to go through the process of conducting a major procurement within Elder Affairs. It's a highly technical process. We have the folks in place to do it. I'm very comfortable. Granted, I've been here less than a week, letting the staff do that work.
So thank you, Commissioner Broder. I'll go ahead and weigh in now. We are taking this issue up because it was under review from my predecessor. Chair Jed Stein had actually started adding this in. So I finally wanted to put this to bed, which is perhaps why we're having a longer conversation. We have a fantastic executive director. We have a great CFO, Derek Flynn and his team, John Scully, that group. I am very comfortable with them doing their job. I would say I would like sort of like a memo around the time that we do the budget that's like, here's your 250 and above, right? And here's what's coming up and down, like something a little more detailed than probably the line item, because to be honest with you, by the time I'm reviewing that entire budget, I'm not as versed in it as you are, right? And I've not served as treasurer. And I know that I defer really to the former treasurers on the board here, or on the commission here, to explain the reasoning, which I appreciated. So I think I'm somewhere with Commissioner Hill and Commissioner Skinner and Commissioner Broder, with trying to also understand that Commissioner O'Brien raises a valid point, which is we do need to know what's going on, especially when it comes to re-upping some of these contracts. So.
Yeah, and I would say that my experience at the IG's office too, one of the things I want to avoid here is sort of the apathy where the same vendors potentially get it, right? So this is not a disparagement on anybody, but I think mindfully making that list and having those conversations about those bigger procurements to make sure we're doing reach out and it's not, the same vendors all the time. And I have seen some of that since I've been here through no particular fault of anyone. But I do think doing that list and that more mindful conversation about it as you're leading into budget and updating us, I think is going to be very helpful. And there may be a procurement that there's an area of specialization. I have been involved in some where the procurement budgetary aspect is absolutely in-house. There may be an expertise that adds on to the drafting of the RFR that requires somebody from outside that space to participate. So I think that would be really helpful.
Chair, can I just add, I would extend that to include just getting an update on all contracts that the commission has entered into, and the amounts and, you know, the purpose of them. It's just, I think it's helpful to know.
So does that give some clarification? I know we actually have them, we have it marked up for a vote, but it's a really stringent, like, let's put a dollar amount in, or how do we want to handle this, commissioners?
I mean, this sounds like more of a consensus on protocol process going forward, syncing up with the budget cycle. I'm comfortable doing that if that's the consensus that appears to be reached going forward. I would think that would require a vote.
That's where I'm at, Mr. Chairman.
I'm good with that. Commissioner Skinner, Commissioner Broder?
Sounds good to me.
All right.
Thank you.
Thank you, Derek. Thank you, John. Thank you, Dean.
We will update our budget policy and process, and Commissioner O'Brien will work with you on that, just to make sure that this is included in there,
Right.
so that it's something that continues from year to year.
Great. Thank you, Derek. Thank you,
Thank
John.
you.
Thank you all. All right. We're going to item number 8. And for that, we are going to Chief Delaney.
Good afternoon, Chair and Commissioners. So today we have for you the final FY 2026 Community Mitigation Fund guidelines. The draft was approved by the Commission several weeks ago. We put those out for public comments. We did not receive any public comment back on them, as they are pretty much the same as last year, which is a little bit more in-depth guidance in a few areas. So with that, we would ask for a vote on the guidelines, and our next steps will be to put the RFR out on the street and start working with our grantees to get applications.
Mr. Chairman,
Commissioner Hill.
just a very quick question. Joe, I know this has gone out to our advisory folks. Everybody's cool and we're ready to go. Yes?
Yep, everybody's all good. We sent it out to about, I think about 300 or so folks, you know, that we deal with all over the place. So we didn't hear any comments back on it.
Mr. Chairman,
Commissioner Hill.
I move that.
Commissioner Hill, may I just wait 1 second?
Yes.
I get where you're going. I appreciate it. But Commissioner O'Brien has her mic off, and then I had a question.
No, I'm ready to do a second if needed.
Oh, okay, so I just want to
I don't
ask,
know about everybody else, but
I'm just wanting to clarify one thing for the record. Is the relief valve in there, Joe? We talk a lot about the relief valve. So if we do have a really, really rock star project we want to help fund, we can do that. Correct?
Yes, that is still in there. Of course, there will, when we meet with our grantees, we will, you know, stress that we are a little bit more financially constrained this year than we perhaps have been in the past. So we want to be careful about asking for additional funds, but they are available if there's really a project that needs them.
Perfect. Commissioners, any questions or comments before I go back to Commissioner Hill? All right, Commissioner Hill.
Mr. Chairman, I move that the commission adopt the FY 2026 Community Mitigation Fund guidelines as included in the commissioner's packet and discussed here today.
second.
Thank you. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Broder.
Yes. Aye.
Aye. And I vote yes too. All right, 5-0.
Well, thank you. I just want to extend my thanks to Mary and Lily for all their help with these, and as well as our advisory committees, our local community mitigation advisory committees and subcommittee on community mitigation on all their input, and as well as all of your input. It is very much appreciated.
Well, and we will extend our appreciation to you, Joe, and your team. So thank you for everything you do. All right, commissioners, with that, we go to item number 10. Any updates? I'm seeing none. Any other business? Do we want a motion to adjourn?
So move.
I'll give that to Commissioner Broder. His first motion. Commissioner Hill, was that a second?
Second.
All right. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Hi.
Commissioner Broder,
Yes.
and I vote yes. That's 5-0. Everyone
Sorry,
had,
awesome that you're doing your own vote with the yes.
I know, I'm trying to get used to it. I'm already trying to get used to
Like
it.
sticking with the yes. I like it.
So, with that said, that's 5-0. Everyone enjoy their Thursday. Thank you, Commissioner Broder. We're so glad to have you.
No, it's my pleasure. A great group, very productive meeting. Looking forward to continuing the work.
We'll poll you and see how this goes. See if this is response. All right. Thank you, everybody.